academics, journalists, and even politicians, for that matter, chief ministers of opposition parties.
People who should be getting bail in the high courts do not necessarily get bail in the high courts, as a result of which they have to move to the Supreme Court.
The victim does not seem to have any role to play, which kind of disincentivizes victims of criminal assault, like rape victims and so on and so forth, to actually approach the court. So what can be done in order to make that more democratic?
Well, you know, your premise that people don't approach the courts may not be entirely correct, because one of
Should courts go beyond the legal framework that is available for them?
Thank you so much. Seldom does one get a chance to ask the CJI questions. We seem to live in a society where one acts first and seeks forgiveness later. This has become particularly true for public authorities acting in a politically motivated manner by detaining activists, academics, journalists, and even politicians, for that matter, chief ministers of opposition parties. All of these actions are taken by deep trust in the faith that justice will be slow to come. What can the Supreme Court do suo motu to deter this behavior which has become commonplace? As an individual, one is helpless. Your thoughts would be appreciated.
Well, thank you very much for that question. I'll not answer the premise, because obviously the premise is what the question is all about, but I'll answer the question. You know, over the last several months and in fact several years, this is something which we have been emphasizing right from the outset, which is that if liberty has to have a value, one, there have to be two fundamental principles. One, a day in excess of what a person needs to be detained is a day too many. But more significantly, the interface of common citizens lies first and foremost at the lowest levels of the legal system. Because by the time cases reach the Supreme Court, they have to travel through the maze of legal procedures. Increasingly what's happening is that we see that a lot in the Supreme Court, and not just in these highly politicized and big ticket cases that you referred to, but in simple cases where you see an accused who's been charged with, say, possession of a commercial quantity of cocaine, or someone who has been charged with something, maybe even an offense involving assault. People who should be getting bail in the trial courts are not getting bail in the trial courts, as a result of which they have to increasingly move the high courts. People who should be getting bail in the high courts do not necessarily get bail in the high courts, as a result of which they have to move to the Supreme Court. Now, this delay, as you rightly say, this delay compounds the problem of those who are facing arbitrary arrests. We have been constantly trying to say that, well, part of the reason for this is the inherent distrust which we have placed in institutions within the country. And I think it's important that we learn to trust people who, maybe in a hierarchical legal system, lie much below, say, the apex institutions, whether in the state or in the Union of India, which is our trial courts. And we have to encourage trial courts to be more receptive to the needs for accommodating concerns of people who are seeking liberty. Unfortunately, the problem today is this, that we look at any grant of relief by trial judges with a degree of suspicion. That means that trial judges increasingly are playing it safe, not granting bail in very important, on important issues or very serious crimes. Now, as we know as judges, just labeling a crime as serious is not an end in itself. At the end of the day, as judges, you have to look at the nitty-gritties of each case and see the fine print in the case. You have to have a sense of robust common sense when you look at a case. For instance, you have an accused in a narcotics case. You have to look at the fine points of the case. What was he doing? Was he a cleaner in the truck? Was he a driver in the truck? Was he the owner of the truck? Was he the person who is really the main person behind the trade which is taking place? Now, unless we therefore separate the grain from the chaff in criminal jurisprudence, it's very unlikely that we'll have just solutions. And to allow for decision makers to separate the grain from the chaff, it's important that we also place a great deal of trust. Now, trust doesn't mean that you don't criticize inaccuracies or incorrect outcomes. Obviously, an incorrect outcome is capable of correction at a higher level. But we cannot begin with a premise of distrust. Because if you begin with a premise of distrust, you're going to therefore have a system where the system itself is inherently, placing more and more importance on the highest levels of decision making within the legal system, namely the Supreme Court, to give relief. And I think that's my concern, that you can't render courts as in the hierarchy as you go up dysfunctional just by the number of very small cases that are placed before us. You'd be surprised at the number of bail applications which every judge of the Supreme Court has to deal week on an end. Most of those cases shouldn't be coming to the Supreme Court at all. We have prioritized bail even during the vacations for the simple reason that these people really at least must have their day in court. Whether they should be given bail in a particular case or not, it's for the judge to decide ultimately. But the reason why we are prioritizing bail is just to send this message across to the nation that those at the most incipient levels of the decision-making process have to do their duties, and do their duties without this feeling that I'll be distrusted or that my career would be on the line if I were to decide in a particular way.
Yes. Yes, please.
Good morning, sir. It's really a pleasure to ask you this question. Continuing from a different side regarding the criminal justice system, as you had just rightly pointed out, most litigants come in contact with the lower judiciary in case of criminal law, the sessions courts. And the approach taken by a criminal justice system seems to be centered around the accused and not around the victims of criminal acts. And what that seems to do is, especially with regards to marginalized sections like women and other marginalized communities, poor people and so on, it seems that people don't want to approach the courts because they don't think that they have any voice in the criminal justice system. It is the state versus the accused, where the victim does not seem to have any role to play, which kind of disincentivizes victims of criminal assault, like rape victims and so on and so forth, to actually approach the court. So what can be done in order to make that more democratic?
Well, your premise that people don't approach the courts may not be entirely correct, because one of the problems which we have is because just the large backlog that we face is reflective of the number of cases which come to the court. But your question was in the context of the victims' rights. Now, there are provisions of our the erstwhile Code of Criminal Procedure, and obviously positions which mirror that even now, which do recognize the important role which victims have to play. And I do believe that, part of the training which we impart to judges, and we now have judicial academies all over the country. More and more judges are now coming out of the 5-year law course. So judges who have, dealt with an integrated course of law. But more important, judges who are now going to judicial academies where they have a multidisciplinary approach to the law and training in the law. Some states for almost 2 years, where judges are also taught, the diverse perspectives which they must bear in mind, and not, for instance, as you rightly said, not have only an approach to jurisprudence which is centered around the accused. Equally, you must necessarily look at the victim. I spoke about the approach to a victim-centered analysis, particularly in context of intersectionality, which I referred to in my judgment in Patna Jamal Wali, particularly from this point of view, that ultimately, judging is so much about theory, but it's all about creating the crime scene in your own mind's eye. The first thing that all of us as judges try and do when you look at a criminal case, whether it's in appeal or even at the incipient level when you're looking at whether to grant bail, is to create an image of what possibly must have happened. And that image which you create of what possibly has happened obviously becomes more accurate as you have evidentiary records before you. But even at the initial stage, you try and create a picture of what possibly would have happened as between the accused, as between the victim. what is the impact of this particular crime on society at large? And these are the distinctions which I guess every judge tries to bring about. Is this essentially an individual crime, however ferocious? Is this really an individual crime which is unlikely to be repeated in future? Or is this something which is more systemic, in which case you need to protect society or the victim of the crime from the perpetrator of the crime? So this is something which is part of the human process of judging, which in that sense lies beyond just theory about justicing. And it's important that we train judges and devote more resources, more investment in terms of training judges on these nuances of the law and not just on the broad principles of formulations of the law.
The question is, should courts go beyond the legal framework that is available for them in case it's critical that the substantive outcome is true to the idea of equality and justice?
That's an amazing question. It's very, it's a question which we could probably spend the next half an hour on discussing, and I'm sure we'll have different people in the audience with different perceptions. Let me tell you that there are different layers to judging. There are aspects to judging which are dependent crucially on the evidentiary record, where you don't want judges to go beyond the evidentiary record. Because if you allow judges to go beyond the evidentiary record in those cases on the theory that judges should be looking at the broader social perspective, there's a danger that individual prejudices would affect the outcome. Therefore, particularly in the context of the administration of criminal jurisprudence, whether an accused is guilty of the crime which he or she is alleged to have committed on that particular day or over a series of transactions, that has to be decided on the basis of the evidentiary record, because that's the only guarantee that the time-tested evidence, tested on the anvil of cross-examination, by the application of a judicial mind to the record, brings about an outcome. And that is the reason why, interestingly, we discarded the jury system in India in the 1950s after the Nanavati trial, the famous Nanavati trial, and did not opt for jury trials. If you ask somebody who is trained in US law, they would find it just incongruous that you don't have jury trials in India. But the reason why we abolished jury trials in India was to eliminate the need for popular prejudice in the decision making in criminal cases. But having said that, to the first part of your question, there are obviously cases where you have to look beyond what really emerges on the raw print of the paper book, particularly when you are dealing with constitutional issues involving human rights questions. For instance, when we dealt with the issue of decriminalizing homosexuality, obviously the material which the court has to deal with has to go beyond the purely legal material which emerges from the facts of the case. You have to look at historical material, you have to look at sociological material, we are engaging with fundamental issues of policy. For instance, one of the cases which I've been dealing with, which was before me just last week, was should the government of India have a different policy in dealing with cases involving ASD, autism spectrum disorders, and what should be the nature of those policies? Now, obviously, in dealing with these sort of cases where you're engaging with the government, you're not dealing with pure law in that sense. The law is given to you by the Rights of Persons with Disabilities Act of 2016. But beyond broad principles like the principle of accommodation, reasonable accommodation, the law will not give you a solution unless you look at everything from the medical to the social to the psychological to the historical aspects of how these issues are dealt with. So depending on which end of the spectrum you are, and though judges may not like to confess this, but I can tell you that in so many of the cases which we deal with, we're actually at the cutting edge of law and policy. We always try, as judges, we always try not to transgress into policy. But so very often you're not framing policy, but you're pushing the policy makers to take a considered decision on matters of policy. But even to push policymakers to take decisions on areas which they have not taken decisions on, you have to understand what the ramifications of the policy are as a judge. And to understand the ramifications of the policy, You have to obviously look beyond just what is legal or what is, the four corners of the statute.
Thank you.